The Illinois State Rifle Association sounding confident that Illinois' challenge to the state's gun ban will move forward to the U.S. Supreme Court after the U.S. Supreme Court denied taking a case out of Maryland. Welcome back. It's Illinois in Focus Daily. I'm Greg Bishop. We've been tracking this story since before the Protect Illinois Communities Act passed the state legislature during a lame duck session through a gut and replace bill that ultimately was enacted within a handful of days from it coming together in final language. Banned 170 plus semi-automatic firearms, from rifles to handguns to shotguns. Prohibited the sale and possession of what the legislation called large capacity magazines. Others point to them and say they're standard capacity, but essentially it was any capacity magazine that is 16 or more for handguns, or any capacity magazine that is 11 or more for magazines for rifles. So that also had a registration component added to it. All of this coming together in the final hours of the January lame duck session in 2023. But then we had lawsuits filed, obviously from an array of Second Amendment advocates. In state court, you had separate lawsuits dealing with issues that were entirely against the state, and then you had individuals getting temporary restraining orders filed all throughout the state. There were 7,000 plus or something like that. So the state level cases did ultimately go all the way up to the Illinois Supreme Court, and the Illinois Supreme Court had some controversy around that, in particular in the Calkins case, where two of the justices denied recusing themselves at a request from Calkins, because those two justices received campaign contributions when they were running for the Supreme Court from Governor J.B. Pritzker, House Speaker Chris Welch, and Senate President Don Harmon, which were all named defendants in the lawsuit in state court. So the state court stuff played out. But you had the federal cases in the Southern District Court that is separate from the state's challenges. So I want to make sure that you're clear on that. There's state court and then there's federal court. So the state court challenges went all the way up to the Illinois Supreme Court and didn't produce an overturning of the law. In the federal courts, there's several cases, right? We had the Beavis case that was actually filed in November of 2022 because Naperville had their ban in place. So he modified his case when the states put its ban in place in January 2023. That went all the way up on preliminary grounds up to the U.S. Supreme Court. They denied taking it. Now it's back into the district court on the merits, but they're holding off on that pending other cases, because there's a case in the federal appeals courts, Veramontes, that was actually decided that the state law is constitutional. So that case could go to the U.S. Supreme Court. So that's an original challenge of the Cook County ban. So that's possible that it could be a writ to the Supreme Court to take the case. But the other case that's currently pending in the appeals court is the consolidated case, Barnett. And you've got 4 different plaintiffs groups who sued shortly after the law was enacted in 2023. That went all the way up and down the courts. On preliminary grounds, initial requests to block the law, the Southern District Judge, Stephen McGlynn, he did indeed give that preliminary injunction for 5-6 days. It was called Freedom Week in the Second Amendment community. Then when it got to the appeals courts overturned McGlynn's preliminary injunction and put the law back in place. And that sparked a whole bunch of different storylines about people who went out and purchased firearms during that 6-day window. Are those firearms legal to have now that the law is back in place? Again, that played out all throughout 2023. And then it went up to the U.S. Supreme Court, and they said they're not going to take it because it was on preliminary grounds. So it went back to the district courts. And then in 2024, you had the district court hold a 4-day bench trial, going into detail of all of the things, comparing military grade firearms to civilian sporting rifles and the differences between them and the uses of semi-auto versus full auto and burst in the military and so on. So that record was created, and then in the fall of 2024, Stephen McGlynn, the federal district judge, ruled that the law was unconstitutional. So then he put a stay on it pending appeal. The state appealed to the appeals courts, and the appeals court kept the stay in place. So we have a law law that has been deemed unconstitutional by a district judge, but the injunction is put on hold pending appeal. And the appeals court sat on it for, 4 months or so without putting out a briefing schedule until the plaintiffs said, listen, we're in limbo right now. We have a judge that said this is unconstitutional and you guys aren't acting on this while the law is still in place. So the appeals court then said that they will have a briefing schedule. Last month, you had the state file theirs as the ones appealing a ruling from a district judge. And then Friday, you had the plaintiffs groups file their briefs. Those weren't made public yet until about Monday or Tuesday. So they were made public, and we went through them the other day here on Illinois in Focus Daily. So that's all the background here, right? Hopefully you understand that, number one, the difference between the state court and the federal court and where we're at in all of this, right? The controversy over Pritzker giving campaign donations to the state Supreme Court justices doesn't impact the federal judiciary. The federal judiciary, they don't run for election. They get appointed by the president for federal judgeships all up and down. So just want to make sure people say, because I do see some comments talking about how the Seventh Circuit is bought and paid for by Pritzker, and that's not the case. At least in the allegations of the campaign contributions going to state Supreme Court justices. So back to the case in the appeals court. You had the 4 plaintiffs groups file in the appeals court, and it's a different panel than what they had on the preliminary stuff from 2024. So that brings in a new equation as to this 3-judge panel with one new judge that took the place of a retiring judge from the previous panel. So that's a little bit of a wild card. But I talked with Illinois State Rifle Association's Richard Pearson, and I got him to react to some of the arguments that the states made in their filings, and they say that they are banning firearms that are dangerous and unusual, and they are reacting to unprecedented societal concerns over mass shootings. Well, recent Supreme Court rulings kind of push back on that idea of using societal concerns as a measure to restrict individuals' Second Amendment rights to keep and bear arms. Here's Richard Pearson, Executive Director of the Illinois State Rifle Association.
Well, you can't take the rights away of 105 or 120 million people because of an incident. You could take driver's licenses away from all the people because there are many more car accidents than there are shootings, but that doesn't work out. So, but this is a fundamental right. So you can't take a fundamental right because of criminal activities. You have to deal with a criminal activity.
And Pearson also noting that the U.S. Supreme Court and their statements denying a Maryland case seem to indicate that AR-15s in particular are commonly used by individuals for lawful purposes, which is one of the fundamental questions to this, right? You've got the issues that the Supreme Court's laid out in previous precedent, talking about how it has to match the text, history, and tradition of the Second Amendment. So if it doesn't match the text, then it's not good. If it does match the text, and then there's no historical analog, then it's not good. But it doesn't necessarily say, well, if there's societal concerns, then the laws can be upheld. But Pearson's confident that the U.S. Supreme Court will take this Illinois case out of the Southern District instead of the Viramontes case that's already out of the appeals court and could be sent to SCOTUS.
Oh yes, I actually think that they're waiting for the Illinois case. And the reason they're waiting for the Illinois case is there's so much more documentation in that case than there was in the Maryland case. So when the Supreme Court makes a decision, they want it to be on solid ground. And so we have something like 10,000 pages of documentation supporting us in this case. So I think that's what they're waiting for. And the combined cases, we worked with the other folks and getting all these cases combined, and we've been fastidious in our documentation on this.
I saw some people comment on this yesterday when we posted just clips of Pearson's conversation I had with him, and people were saying, why does it take 10,000 pages to prove to a court what the 27 words of the Second Amendment mean? It's an interesting question, but that is the space we are in this constitutional republic of laws getting passed by states, being challenged in the courts, and the equal branches of government and the checks and balances between the executive, the legislative, and the judicial branch, and so on. But back to Pearson, he says, listen, whichever way this case goes, it's going up to SCOTUS.
So whatever side wins or whatever side loses, it doesn't matter how you look at it, I guess. The other side will appeal it to the U.S. Supreme Court. No question.
And he is thinking that if there's an expedited timeline to get this out of the appeals court, it could come up possibly before the year's out.
I'm pretty much looking forward to get the Seventh Circuit arguments under our belt. There's an outside chance if we got it done by September or late September, we could make it into this session of the U.S. Supreme Court. So that's what I'm hoping for.
That's one thing to hope for, but realistically, looking at the timeline, you had the Seventh Circuit Court of Appeals sit on the case for 4 months without any action, and then how long is it going to take once they do schedule oral arguments? Because we still have to wait for the state to file its final briefs in this case, and that's expected before the end of the month. And then we get an oral argument schedule. Could that be for September? Could they rapidly put out a order, be within weeks? Or are we going to have to wait months until early next year? So is it possible that it's going to happen before the end of this year? Richard Pearson's hopeful, but obviously he also recognizes the speed of which courts move sometimes.
At the speed of sloth.
So what's going to happen? Obviously, we'll be tracking it for you, but it's just one of many things that the Illinois State Rifle Association's busy in court with. Here is Pearson talking about the slew of other cases they have pending in the judiciary.
Well, we are busy. Of course, we have the Schoenthal case, which are now waiting for arguments before the Seventh Circuit also. So we have 2 cases up before the Seventh Circuit. And that one deals with firearms on public transportation. Okay, so that's one. Then we have the Reese case, which is the Freedom Week case, when Judge McGlynn said you could buy firearms, sell firearms on the PIC Act list. And so that case has been returned over. The Third Circuit, Illinois Circuit, said that sided with the state, so we're on our way to the Illinois Supreme Court on that one. Then we have a variety of other cases down the line dealing with various issues. One of them would be the Brown case, which is on its way to the Illinois Supreme Court for the 3rd time. Which declares the FOID card in the home unconstitutional. So those are the major ones. We have a lot of other cases dealing with people who have daycare centers having to disassemble their firearms even though they're in a safe, so forth and so on. So we have a lot of other cases coming up. They're not as major as these cases, but they all make a difference.
So Pearson clearly, with the State Rifle Association, says people should understand that while others may criticize in the Second Amendment space what ISRA does, he says they're not going anywhere.
Well, here's the thing. People kind of poo-poo the State Rifle Association, but we are not going away. We're going to continue to attack and secure Second Amendment rights for the people in Illinois, no matter what. So.
Again, Illinois State Rifle Association's Executive Director Richard Pearson, part of the conversation I had with him yesterday, just to get the latest and where we're at in the gun ban litigation. It seems to come in waves, ebbs and flows, right? We get a whole bunch of activity for a couple of weeks, and then things kind of go radio silent. So I think we're kind of in that phase where the next few weeks we'll get the filing from the state, and hopefully we'll get a quick update on any kind of oral arguments schedule in the Seventh Circuit, and we'll bring it all to you here with Illinois in Focus Daily. I'm Greg Bishop. Like, subscribe, hit that notification bell, and wake up with us each and every weekday morning for more Illinois in Focus.